Define due process. Sure, in the limited amount of space that I had in a text response, I said that one way to think of due process is that a person has a right to be heard in court with counsel and then one appeal. That's one way to think of due process, but that's a pretty short way. I have right here Erwin Chemerinsky, one of the preeminent constitutional scholars in the country. I have his book on constitutional law, and there's an entire chapter on due process, so it gets pretty complicated. But let's read his basic definitions. Here we go. The Fifth and the 14th Amendments, respectively, provide that neither the United States nor state governments shall deprive any person of life, liberty, or property without due process of law. This clause has been interpreted as imposing two separate limits on government, usually called procedural due process and substantive due process. Let's talk about procedural due process first. Procedural due process, as the phrase implies, refers to the procedures that the government must follow before it deprives a person of life, liberty, or property. And that's really what I was talking about in my response to him. Classic procedural due process issues concern what kind of notice and what form of hearing the government must provide when it takes a particular action. So the procedures that are involved, going to court, etc. What about substantive due process? It asks whether the government has an adequate reason for taking away a person's life, liberty, or property. In other words, substantive due process looks to whether there is a sufficient justification for the government's action. Let's get a couple of examples from Professor Chemerinsky. For example, if a law is in an area where only rational basis review is applied, that's most of the time, substantive due process is met so long as the law is rationally related to a legitimate government purpose. But if it is in an area where strict scrutiny is used, less common, such as for protecting fundamental rights, then the government will meet substantive due process only if it can prove that the law is necessary to achieve a compelling governmental purpose. He spends about 50 or 60 pages talking about it. This, if you're interested in constitutional law, is an excellent and pretty accessible for the non-lawyer book on con law. I think it cost me $80 or something on Amazon, and it's a very good reference material. I wouldn't just sit down and read it from front to back, but when you have a question about constitutional law, it's probably explained in this book.